Just a little over 24 hours ago, a jury in Barrow County convicted Colin Gray, the father of the accused Appalachia High School shooter, of all 27 counts that he faced, including 2 charges of second-degree murder. That was the verdict in the criminal trial of Colin Gray, but there may be more to the story, including more and possible civil litigation. Our Grace King, who's covered this story and this case from the very first day, joins us now. Grace, got the verdict yesterday in Barrow County, but you are hearing that there's a possibility of civil litigation now.
Several of the families affected by the Appalachia High School tragedy filed anti-litem notices a couple months ago, saying that they did intend to sue some of the government agencies that were involved with the Appalachia High School shooting. That does include the Jackson County Sheriff's Office that had previously investigated threats on Discord, but also the Barrow County school system. And I spoke with one of those attorneys today. He told me the evidence he saw at trial is actually helping them build their civil suit now. So take a listen.
It's hard to explain what took place on September 4th, 2024.
How the hell is he going to walk across the yard with a long rifle and get on a bus?
Authorities say 14-year-old Colt Gray wrapped an AR-style rifle in poster board, took it on a school bus, and threw out Appalachia High School, virtually undetected.
I heard a voice that said he's got a gun.
His first period teacher, Suzanne Harris, emailed administrators at 8:46, concerned about a new kid, asking about active shooter drills. By 9:50, she testified she was in the front office, talking to Assistant Principal Dee Martin.
She told me that the book bag looked heavy and that she felt like there was definitely something in there.
But on the stand, Martin acknowledged they didn't know or ask what Colt Gray looked like, other than this 4th grade yearbook photo. And they accidentally questioned a different student with an almost identical name.
So he had been missing then for 32 minutes, correct?
Correct.
Video shows the right Colt Gray was in the bathroom until 10:22.
I saw that it was him and that he had a gun.
Jurors convicted Colin Gray, Colt's father, on 27 counts, including second-degree murder, for providing the firearm used after sufficient warning his son could harm others. But the legal action won't stop there.
It goes farther than just Colin Gray. It goes to accountability on all those involved.
Attorney Mike Pugilese represents the family of Mason Schermerhorn, one of the students killed, and Taylor Jones, one of the students shot in pending civil suits.
There was a lot of information gained from that trial, the testimony given. School officials knew from what a teacher's testimony was at approximately 8:50 in the morning that they had a problem on their hands.
He wants policies and procedures to change so nothing like this happens again.
It just didn't die yesterday with a verdict. It goes on, and then we can make progress and we can make change in this system.
And that attorney told me he intends to file the actual lawsuit in a couple of weeks once he has time to kind of incorporate the rest of the evidence from this trial. Of course, this is something they've been working on since September 4th, but now that they have kind of some of those final outstanding pieces, they are getting ready to actually file that in civil court.
And Grace, you got into this a little bit in that story, but I want to ask you in a little more depth here now. It is difficult, very difficult, just under the legal framework of our state to sue government entities like a school district or a sheriff's office. How does the attorney plan to try to get over that?
It's very difficult, but he says he thinks this is one of the cases where they could actually get around some of those. They're looking at specific policies, where they followed, where they not followed, what protocols were in place. There wasn't a lot of urgency between that first email and that class change. He was saying, why isn't there soft lockdown? Why isn't there this? Those are some questions we did hear at trial that, some of the SROs said they don't always jump to lockdowns right away because then you could lock the shooter in a classroom with people. So you don't necessarily know whether that would or would not have prevented it. But there are a lot of questions like the yearbook photo or just some of the steps that were taken that it depends on the policy failure. He says it's impossible to prosecute cases against government agencies where negligence is the only claim. And a lot of what Colin Gray was convicted of, it does have to do with negligence. You saw this and didn't act. You saw this and didn't act. It can't be that way with the school districts, but he says some of the actual actions they took could possibly lead to the case. So,
what are the families who are in support of this road towards civil suit saying, and more broadly, what is the Appalachia and the Barrow County community saying about all this?
I think it really depends on who you talk to. So I have talked to Mike Pugilese. He represents the family of Mason Schermerhorn and Taylor Jones. They're obviously, looking to move forward with this. He says he's been talking to Brianna, Mason's mom, throughout the course of the trial. And at the end of it, she was just numb. She didn't really have a reaction to the verdict. It's just nothing will ever bring her son back. nothing can ever make up for what happens. But at the end of the day, they want to make sure that there are policies in place that hopefully this won't happen again. And civil lawsuits are typically the best way to go about that. Criminally, you hope that this will set an example so that other parents won't act that way, but you never really know. So it just kind of depends. A lot of people in the Barrow County community, some of them are divided. They're not sure whether Colin should have been convicted on these counts because he's not the one who actually carried out the shooting. You have a lot of people who are saying, how did you miss all of this? How did you let this happen? He really should be held accountable. But it's very divided. And I think the way Mike put it to me, just talking to the families of the victims, numb. There's nothing that'll bring them back. And it's a step towards justice. It's just never going to be enough.
And so much of that just gut-wrenching testimony and the history and was replayed publicly throughout the 12 days of the trial of Colin Gray, and it all flows back to that horrible day in September of 2024. Grace, you were in the court through everything. You were there when the verdict was delivered yesterday. Talk about the impact to these families in the courtroom as they listen to the verdict. Can you just describe what that moment was like inside the courtroom yesterday?
It was just, everyone was holding their breath. They said the jury had a verdict. It was very quick. Everyone wasn't sure if it was an actual verdict, if the jury had a question. So everyone was just kind of rushing inside. Is this it? Is it this it? And then everyone was just kind of, holding hands, holding their breath, waiting to hear it. And as soon as that the first count they read was second-degree murder, which is one of the hardest charges to get in the entire indictment. So it was kind of, if you get the second-degree murder charge, that means you have the child cruelty, you likely have the rest. So as soon as that guilty count was read, you could just hear kind of that breath and just that release of emotions. A lot of them, again, it's just hard to react to something because this isn't the person who actually carried out the shooting. This isn't going to bring back your loved one. But it's just knowing that it was over, knowing that they've reached this point and at least part of the justice process is over. Of course, this will likely be appealed, but at least this portion is over for now. And I think just knowing that, they might only have to relive it once more or twice more, depending on however these lawsuits go.
And you allude to that. That's another component of this. Colin Gray was the first of the two people charged in connection to the Appalachia High School shooting to stand trial. His son, Colt, is the other one. He is the accused shooter here. He has pleaded not guilty. He hasn't gone before a jury yet. For people who've been asking, and I'm sure you've gotten these questions too, what about Colt? What happens to him? What do we know about where his legal case stands?
We're not really sure. So Colt has gone through 4 or 5 attorneys at this point. So that obviously slows the process down. Every time we've gone to a hearing, the attorney often says, Judge, there's a lot of discovery in this case. I've just been handed it. I need more time. So that every change of attorney slows this case down. The last change of attorney was in late December. We do know that there's a hearing scheduled, I think March 18th for Colt Gray. At last check, they were hoping to have his medical evaluation that might give us more insight onto his mental state. We heard a lot in Colin's trial that Colt thought he had acute mania. He might have suffered from anxiety. He might have suffered from depression. But part of the problem with Colin is that he never actually took Colt to get diagnosed. He's never been evaluated by a licensed professional. So they've been working on that for a couple of months now. That's a long process. They're hoping in March to kind of sit down and say, hey, this is what we have. This is how we want to move forward. One of Colt's earlier attorneys indicated that he had no desire to go to trial. He would take a non-negotiated plea offer. The district attorney's office says they will not be offering a plea. The families were kind of split on whether they wanted Colt to go to trial or not to go to trial at that point. If he does go to trial, I watched the video of the shooting. There are multiple angles of it. It's in high definition. It's very hard to say who is that individual there. He's not, you watch him walk into the bathroom, you watch him walk out in the bathroom. I think it's very hard to kind of say, that's not me, I didn't do it when you have that kind of evidence. I would imagine he might opt for something we've seen in a lot of these high-profile cases, which is no jury, because it's, at the end of the day, that emotion can play into the jurors. You're also going to be looking for jurors, if you do go that route, that didn't know about the dad's conviction, because if the dad's convicted, it does kind of muddy the waters a little bit on that presumption of innocence. Of course, the DA, Brad Smith, yesterday he said he hopes that one won't have an impact on the other, but it's just hard to see how that wouldn't.
Almost 2 years out now from that 2024 shooting, well over a year and a half. One of these cases has now reached a verdict, at least at the trial stage, a conviction of Colin Gray. Still waiting to see what happens to Colt Gray. And as you pointed out, too, appeal seems all but guaranteed of the Colin Gray verdict, particularly because, and I want to ask you this as the last question, this is the first time in the history of our state that a jury has been tasked with answering the question of whether a parent can and should be held criminally responsible for the alleged actions of their child committing school shooting like this.
Absolutely. And with respect to the second-degree murder charge, it's the first time in the country you've seen something that high. Involuntary manslaughter is what the Crumbly parents up in Michigan were charged with. That's a bit different. It's more based on the reckless conduct idea. Second-degree murder is where you typically see more of that accomplice role. It carries a lot more jail time. It's a lot more serious. So that in itself is just so legally interesting that, of course, that did happen here, but we will have to see if that sticks. A lot of times during the trial, the judge would say, you know, I've looked at this evidence, I've looked at this, take it up on appeal. Like, this is the best guidance I have according to the law. You're welcome to appeal that. There were certain things that the defense made sure to preserve. They said, you know, we're not going to object to that, but I want to make sure that this motion is preserved for appeal. Can you make a note of that for appeal? Appeal came up throughout the entire trial with a lot of the legally murky things that were decided. Of course, the defense thought it would be unfair to have jurors from Hall County because it was too close. That's something they might try and appeal on. The defense was not happy that they used the interviews with the dad at the house or the next day when he thought he was just giving information about his son and not himself. They believe that shouldn't have gotten in. And then, of course, there was a testimony from Jenny Gray, Colin's daughter, where she said, he asked me to lie for her, and that stunned the defense attorneys. They had no idea that was coming. They were very upset. They said prosecutors should have shared that with them. The judge said, I don't think they should have, but they said they weren't prepared because of that. That's something they might try to appeal on. So there's so many different avenues they might try and take on appeal that this is just one of the first of its kind. They made sure to preserve every little challenge they had in the official records so that when it gets handed over to an appellate court, all of their objections are there.
We know you're going to be watching every step of the way, and probably the first thing that's going to happen next is going to be sentencing. That has not yet been scheduled, but we know that's going to be coming up shortly, we expect.
Yeah.
Grace King, as always, thank you very much.